Welcome from spats over Instagram images to the enduring resale wars. Today I'm going to discuss some of the biggest cases to watch for in 2021, from lawsuits over the unauthorized use of others' imagery to litigation centering around whether cosmetics giant Coty and hipster retailer Urban Outfitters misappropriated trade secrets in the course of M&A discussions, to the enduring fights that Chanel has waged against players in the burgeoning resale market. There are an array of interesting lawsuits set to unfold further in 2021. Here is a look at a handful of the many cases we have our eyes on. My name is Scott.Slavick. I am the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, searching and clearing new global brands on a rush timeline, reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. The first case to watch for in 2021 is Emily Ratajkowski's Mood Forever Instagram post that got her sued in 2019. According to a complaint filed in 2019, photographer Robert O'Neill claims that Ratajkowski and her corporate entity, Emrata Holdings, ran afoul of federal copyright law when the famous model posted one of his photos on her Instagram story without his authorization. Unlike the vast majority of paparazzi photo cases, this one did not swiftly run its course and end in a confidential settlement agreement. Instead, the two parties have been going back and forth in the case, with Ratajkowski's counsel calls a bad faith quest for an unsubstantiated payday. In one of the latest rounds, counsel for Ratajkowski is sought to have the case decided early and in her favor, arguing in a summary judgment motion in September that O'Neill failed to make his case on multiple fronts. In a subsequent filing on October 28th, Ratajkowski's counsel asserted that the paparazzi photographer's cross motion for summary judgment should be denied, and Ratajkowski's motion for summary judgment, which would decide the case ahead of and in lieu of a trial as a result of a lack of disputed facts, should be granted. The basis for Ratajkowski's motion: according to Ratajkowski's opposition to O'Neill's cross motion for summary judgment and reply in support of her own motion for summary judgment, counsel for the model sets the stage by asserting that O'Neill regularly parks outside her home and follows her in hope that he can take her photograph without her permission and then sell it to a third party. That's precisely what happened last fall, Ratajkowski claims, when O'Neill took 9 photos of her, one of which she subsequently posted to her Instagram story along with the caption, "Mood Forever." According to Ratajkowski, her caption, along with the fact that her face is covered by a bouquet of flowers in the photo, which appeared on her Instagram story for 24 hours, serves to comment on her perception of the predatory nature of O'Neill's practice. Piggybacking on the claims that she made in her motion for summary judgment, Ratajkowski argues that she is entitled to a win as O'Neill has failed to prove the basic elements of copyright protection, and even if he had sufficiently proved that his photo is in fact subject to copyright protection, her transformative use of the photo constitutes fair use, thereby shielding her from copyright infringement liability. The second case to look out for is actually a series of cases. It seems misappropriation by acquisition cases are having a moment in the fashion beauty space right now. On the heels of Olaplex landing a $66 million win in the trade secret suit it filed against L'Oreal in January 2017, less than a year after the enactment of the Federal Defend Trade Secrets Act, 3 similar suits have since been filed. Leteau sued Urban Outfitters in June, alleging that the company has stolen its trade secret protected business model under the alleged guise of a potential acquisition in order to create a rival fashion rental business, Nuuly. Around the very same time, Seed Beauty, the Southern California-based company responsible for creating, developing, manufacturing, storing, selling, and distributing the products of the billion-dollar beauty ventures of Kim Kardashian and Kylie Jenner, filed 2 separate trade secret lawsuits, one against Kardashian's KKW Beauty and another against Coty and Kylie Cosmetics in connection with Coty's acquisition of stakes in the half-sisters Buzzy brands. In both of the complaints, Seed alleges that as a result of the cutting-edge nature of its business model, the details of its creative and logistical development services, and the terms of the exclusive relationships it has with its beauty brand partners amount to highly sensitive, confidential, and trade secret information. Those highly sensitive and confidential elements of its business are at risk, Seed claims, due to Jenner and Kardashian's respective headline-making deals with Coty. All three cases, which raise interesting and potentially growing issues given the industry consolidation due to COVID-19 and the resulting market volatility, are still underway in the respective courts, with Urban Outfitters, for one, arguing this summer in response to the suit filed against it that Latote is falsely accusing it of misappropriating and using unspecified trade secrets, which Latote supposedly shared with it during those discussions to launch Nuuly, Urban's own fashion rental subscription business. Stripped of its rhetorical flourish, Urban argues, against Latote's complaint, boils down to two core contentions. One, pursuant to a written non-disclosure agreement, Latote shared supposed trade secrets with Urban, although the complaint never identifies a single specific trade secret disclosed to Urban. And two, because Urban thereafter launched a business that competes with Latote, Urban must have misappropriated and improperly used those purported trade secrets. In lieu of identifying the trade secret information with any specificity, Urban alleges that Latote makes vague references to broad areas of technology and practices within the rental clothing industry, and asks the court to infer that something there must have been a trade secret, and that Urban must have misappropriated and used Latote's trade secrets in order to launch a competing business, notwithstanding Urban's long-standing leadership within the retail fashion industry. Third on my list of cases to watch are the ongoing battles between Chanel and The RealReal and Chanel and What Goes Around Comes Around. Both are still playing out in federal court and have heated up in recent rounds. In late October, for instance, The RealReal sent a letter to Judge Gabriel Gorenstein of the U.S. District Court for the Southern District, asking the court to permit it to amend its answer to assert antitrust and related anti-competitive counterclaims against Chanel in light of its discovery of new evidence about Chanel's motivation in bringing various trademark-centric lawsuits against its competitors, including the one it filed against The RealReal in November 2018. Along with the letter, Resale Company submitted a proposed amended answer and counterclaims, which follow from its allegations that Chanel made in its February 2019 amended complaint, including that The RealReal has engaged in trademark infringement and counterfeiting by offering up pre-owned Chanel products on its e-commerce site and its brick-and-mortar outpost. The crux of The RealReal's antitrust-centric arguments is that Chanel has been quietly carrying out an aggressive campaign of exclusionary and anti-competitive conduct aimed at monopolizing the market, and thus the supply and price of its goods, both new and pre-owned, to the detriment of its competitors and consumers alike. Chanel has since pushed back, arguing that The RealReal's attempt to lodge antitrust claims against it is a transparent tactic to divert attention away from the counterfeiting claims at play, and claiming that even if The RealReal's antitrust claims are not time-barred, Chanel argues that they are. The resale company has failed to adequately show that Chanel actually monopolized or attempted to monopolize the market, and that its tortious interference claims are similarly without merit. As for Chanel versus What Goes Around, an interesting round was underway this summer in the midst of a discovery dispute between the parties. Despite instructions from the court that Chanel must specify with particularity and detail the products that What Goes Around sold that are not genuine, that were falsely advertised, or that were acquired under circumstances in which the first sale doctrine does not apply, in response to which What Goes Around would share all documents, witness statements, and arguments in connection with those products that it proposes to use or refer to at trial. What Goes Around alleged that Chanel had failed to make good on its end of the deal. The squabble raises the question of what products fall within the realm of counterfeit or otherwise infringing, and what constitutes infringement more generally, with the parties clashing over whether bags that were made in authorized Chanel factories, but that were never received by Chanel for quality control and approval, and were never actually sold by Chanel or any of its authorized retailers, were to be considered not genuine. Chanel argued that some 51 bags that What Goes Around sold are counterfeit because they were never quality checked, authorized, or sold by Chanel. According to a July 31st, 2020 letter that Chanel sent to the court, nearly 4 decades of precedent from the U.S. Court of Appeals for the Second Circuit establishes that, simply put, goods that are not approved for manufacture and/or sale by the trademark owner are not genuine goods, and the sale of such unapproved products give rise to trademark infringement. Meanwhile, what goes around called foul, arguing that a Chanel bag made by an authorized factory does not morph into a counterfeit simply because the factory does not follow some element of a designated protocol. In that same vein, what goes around asserts that such a claim is hardly one that speaks to counterfeiting. At the same time, both The Real Real and What Goes Around have called attention to Chanel's relationship with Farfetch, in which it maintains a minority ownership stake, and in particular, its failure to take the uniform legal action against the fashion marketplace for offering up pre-owned Chanel bags in the same manner as they have. This shows that Chanel knows that they are not engaged in wrongful conduct and instead has chosen to make a deal with one competitor and attack other competitors, namely What Goes Around and The Real Real, as part of a bad faith pretextual campaign to quash legitimate competition. I'm Scott Slavick, and those were today's cases to watch for 2021, although I'm sure we'll see some more interesting lawsuits emerge as the year continues. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.